StudyIQ IAS, अब तैयारी हुई अफोर्डेबल।
In previous session, we were talking about Article 32, Part 3 of Indian Constitution. We talked about 4 clauses which constitute Article 32, right? Can you quickly remember what those 4 clauses were? We discussed, right? Thereafter, we talked about 5 writs. Then we talked about difference between writ jurisdiction of Supreme Court and High Court. We also played certain rapid fire question round, right? Thereafter, we discussed 33, 34, 35 was left, right? So let's have a short recap and thereafter 35 and then we are going to discuss DPSPs.
कई बार मन में सवाल आता होगा कि इस प्रिपरेशन को शुरू तो कर दिया है, मज़ा भी आ रहा है, तभी आप इस वीडियो में हैं, सीखने को तो मिल रहा है, लेकिन क्या उतना पढ़ा जा रहा है जितना इस एग्ज़ाम को क्लियर करने के लिए ज़रूरी है? क्योंकि अल्टीमेट ऑब्जेक्टिव तो क्या है? योर नेम इन मेरिट लिस्ट। तो देखिए, कंटेंट तो सेम है, लेकिन कंटेंट को यूज़ करने की हमें स्किल डेवलप करनी है। कैसे होगी वो स्किल डेवलप? पहले तो भाई टाइम से हर एक सब्जेक्ट का कंटेंट तैयार होना चाहिए। अगर आप वो कर रहे हैं ठीक है, लेकिन इफ़ यू वांट टू टेक हेल्प तो आप स्टडी आई क्यू की हेल्प ले सकते हैं। जो स्टडी आई क्यू का P2I प्रोग्राम है, आप स्टडी आई क्यू ऐप या वेबसाइट पर देख सकते हैं। P2I मतलब प्रीलिम्स से लेकर इंटरव्यू तक का एक प्रोग्राम। तो ये एक प्रोग्राम के अंदर 4 फेजेस हैं। तो उस 4 फेजेस के थ्रू पहले ही फेज में आपका कंप्लीट सिलेबस हो जाएगा। तो इट इज लाइक द बेसिक थिंग, ये तो करना ही है। इसके बाद आता है कि हमें स्किल्स डेवलप करनी है, यानी कि उस कंटेंट का प्रीलिम्स में इस्तेमाल हो सके, उस कंटेंट का मेंस में इस्तेमाल हो सके, यानी कि आंसर राइटिंग। फिर हमें असेसमेंट चाहिए बीच बीच में, जिससे कि हमें कमियां पता लगती रहें। तो इसके लिए भी P2I में आपको प्रीलिम्स मेंस दोनों की टेस्ट सीरीज दी जा रही है। वीकेंड पर भी टेस्ट होते हैं, प्लस डेली मेंस आंसर राइटिंग होती है। तो आपको नहीं लगता अगर इतना कोई मेहनत आपके साथ कर ले तो आप करना तो चाहते हैं, बट एक पाथवे नहीं है, तो P2I प्रोग्राम वो पाथवे आपके लिए साबित हो सकता है। तो टेक हेल्प ऑफ दिस। फिर आपके मन में कभी कभी जो डाउट आता है उसको ढूंढने के लिए आपका काफी समय ज़ाया हो जाता है। ज़ाया इसलिए कह रहा हूं क्योंकि हो सकता है उस डाउट को ढूंढने के लिए आपने 1 घंटा लगा दिया, क्योंकि उससे एसोसिएटेड काफ़ी सारी चीज़ें नई नई पता लगती चली गई आपको। ऐसे में इस टाइम को रिड्यूस कर सकते हैं आप। एग्जाम ओरिएंटेड क्या उस डाउट से रिलेटेड नॉलेज आपको चाहिए, वो आपको एक पर्सनल मेंटोर बता सकता है। तो इस कोर्स में फैकल्टीज तो आपके साथ हैं ही, इस पूरी जर्नी में आपको पर्सनल मेंटोर दिया जा रहा है। आप उसकी हेल्प लीजिए। आप कॉल व्हाट्सएप पर कभी भी उनके साथ कनेक्ट हो सकते हैं। उनका नंबर आपको इस कोर्स में स्पेसिफिकली आपको अलॉट होगा। तो अल्टीमेटली आपका टाइम बचेगा, कॉन्फिडेंस आएगा प्रिपरेशन में। फिर जैसे आप प्रीलिम्स क्लियर कर लेते हैं तो उसके बाद मेंस रेजिडेंशियल प्रोग्राम, ये इसका सेकंड फेज मतलब थर्ड फेज कहिए, क्योंकि पहले फेज में फाउंडेशन है, फिर सक्सेस इन प्रीलिम्स है, फिर MRP मेंस रेजिडेंशियल प्रोग्राम। फिर उसके लिए आप दिल्ली बुला लिया जाता है आपको। यहाँ पर आप मतलब जो फूडिंग लॉजिंग एवरीथिंग इज टेकन केयर बाय स्टडी IQ। और उसके बाद फिर रिगरस प्रिपरेशन होती है आपकी मेंस के हिसाब से, यानी कि हर एक जो आपका पेपर है, GS है, लैंग्वेज है, essay है, हर एक की तैयारी यहीं पर हम आपको अपने सामने कराते हैं। उसके बाद जैसे आप मेंस क्लियर करते हैं तो इंटरव्यू गाइडेंस प्रोग्राम, वहाँ पर आपके कोहोर्ट्स बनते हैं, जिसमें डिस्कशन के थ्रू जो आपके अदर एस्पिरेंट्स हैं, जो आपके साथ इंटरव्यू देने वाले हैं, तो आप अपनी स्किल्स को पॉलिश करते हैं। साथ में ब्यूरोक्रेट्स, फॉर्मर टॉपर्स, ये सब फैकल्टीज आपको मिलकर गाइड करते हैं। फाइनली व्हेन यू आर थ्रू इनटू द मेरिट लिस्ट, देन फिर आपको लगता है कि हाँ, इट वाज ऑल वर्थ इट। मिलते हैं आपसे क्लासेस में, ख्याल रखिए। जय हिंद।
So Article 33 was talking about empowering Parliament, that Parliament can prohibit, abrogate fundamental rights with regard to certain services, right? We discussed. Now, I'm giving you the star point. You should search about ESMA, ESMA, Essential Services Management Act. The question is, if ESMA draws power from Article 33, what kind of services are part of ESMA? Can such law can be made by state legislature also? So this is my question from you, and you have to mention in comments, okay? Don't consider that UPSC is going to ask questions specifically on the language which is there. They want to check your analytical side, how you understood it, and whether you are able to apply it in current scenario if some developments are made. Because during the doctor strike, government was saying we can impose or we can use ESMA. We can take their right to agitate, okay? So this is an important debate. Thereafter, we discussed Article 34. We talked about differentiation between martial law and emergency, right? Then 35 talks about power of Parliament to make law regarding enforcement of certain fundamental rights. Now, important thing is, it says that regarding certain specified fundamental rights, only Parliament can make law, right? So, सबसे पहले तो why only Parliament can make law regarding certain specified fundamental rights? The answer is to bring uniformity throughout the country. For example, if certain fundamental right is abridged by someone and Parliament is making law that all over India this is going to be punishment. So it means it is bringing uniformity throughout India, right? Because if nature of fundamental right is same and punishment of their infringement should also be same, right? Now, please remember, if UPSC makes a statement drawing inspiration, or you can say question can be asked from Article 35, that as per Article 35, no state legislature can make law regarding enforcement of fundamental rights. Now tell me, a student will tell me the statement will be true or false. I'm repeating the statement. As per Article 35, no state legislature can make law regarding enforcement of fundamental rights. Some students might say, sir, this question is quite easy. It is quite visible here, is that only in the Parliament and not in the state legislature, right? So those students who are saying yes, my friends, answer is no. The statement is false. You know why? Because statement was saying no state legislature can make law regarding enforcement of fundamental rights. It means all fundamental rights. But Article 35 is saying certain specified fundamental rights which are specified by Parliament, that in this regard only we are going to make law because uniformity in punishment is needed. But when I'm saying fundamental right, it means fundamental rights which are mentioned in Constitution as well as fundamental rights which are time to time interpreted through Supreme Court, right? So regarding other fundamental rights, state legislature can also make law, right? So I hope now you are not going to get trapped into the question. These are the intricacies on which we have to play. The examiner knows where you are going to get trapped. Now, since we have gone through this part 3, we need to know in which case Parliament shall have the power to make law. So one is when it comes to prescribing the residence as a criteria, right? Article 16 means regarding public employment. This is one criteria where Parliament shall make law. Apart from this, empowering courts other than Supreme Court and the High Court to issue directions, orders, writs or kind of enforcement of fundamental rights. We discussed about this in Article 32, right? So coming from Article 32, it specifically says Parliament has power. Then restricting or abrogating the application of fundamental rights to members of the armed forces, 33. This power only, lies with Parliament, right? Apart from this, indemnifying, compensate any government servant, any other person for any act done, means we are talking about martial law. So in this regard, power is with Parliament, okay? Now, Parliament laws for prescribing punishment. So there are some examples, for example, human trafficking. Okay, regarding human trafficking, for example, regarding untouchability, Article 17, Parliament has power to make law, Parliament make law. 35 of the above mentioned, even if they fall under state list, Parliament can make laws on these subjects, on these issues, right? Now, what are the popular criticism of fundamental right? Most popular one are, even if Constitution has given us so many fundamental rights, but there are so many restrictions also, excessive limitations also, reasonable restrictions are there. And that is why, due to the ambiguity, or you can say multiple interpretations, applications of these restrictions, many times people are not able to access these fundamental rights. Second is no social economic rights, because socio-economic rights are mentioned in DPSPs. And those rights which are mentioned in Part 4, they were not given the status of fundamental rights. So this is another criticism, right? And you should also know that you should not just understand or remember the words. Okay, you should remember that when we read our preamble, so preamble says that social, economic justice are priority. So if they're priority, then why they were put under DPSPs and not fundamental rights? So my friends, when you write answer in mains, so at that point of time you need to bring substantiveness, logic behind. Means this is one criticism, but why this criticism? That logic need to be reflected in your answer, not just this pointer. Okay. Now, no clarity. As I told you, ambiguity is there. For example, right to life and personal liberty. But life, what constitutes life? It was not clearly mentioned. According to some people, some scholars, life means you're living, you're breathing, you're alive, and that life of yours need to be protected. But in Maneka Gandhi case, we discussed that life is not just mere existence, life is living with dignity, right? So no clarity as such in this part. No permanency means there can be situations where you cannot exercise your fundamental rights. Suspension during emergency means your fundamental rights can be taken away. I mentioned this, Article 358, 359. We are going to talk about this in detail when we discuss emergency. Expensive remedy, because consider a poor person in some distant village in one corner of India, and his or her fundamental rights are abridged, right? And local administration is not supporting. Now, this person came to know that there is Article 32, and under this person can knock the door of Supreme Court. But can this person afford that? So it means accessibility of justice is an issue which has not been dealt in a manner it should have been, right? Preventive detention. This preventive detention as a method has been abused to curb your fundamental rights. No consistent philosophy. It means so many variations are there, or no variations are there. That is why multiple point of views on fundamental rights keep on popping up. Okay. You should also remember this in this context. When I say no consistent philosophy, so my friends, when we talk about fundamental rights, DPSPs, or any part of our constitution, they are outcome of one or other political philosophy, and they have roots, in ancient time. But when we look at Indian Constitution and we look at fundamental rights, we see so many variations, so many philosophies compiled together beautifully, right? Some of you might be wondering, sir, how means we are not able to relate with it. Take example. Means our constitution talk about preamble, and our constitution talk about socialism as well as socialist as well as liberty. So traditionally they are totally different philosophies. And when you see this in part 3, you see in Article 19 we talk about liberty, right? So liberty is there. We also know that there are instances where liberty is curbed for the social interest. So it means society can be given primacy over your individual right in certain circumstances. So it means somewhere socialism, somewhere liberalism, there's a mix which is used. So some people use it as criticism, but you should also consider it as a beauty, because purpose was to make a constitution, make fundamental rights which are more applicable, and they actually deliver to the aspirations of the people, right? Now we need to talk about DPSP's part 4. And there is an interesting story behind it. Starting from 1945 Sapru Committee, which said in India we should actually have two kinds of individual rights, and thereafter group rights. So they said some should be enforceable by law and others should be not enforceable. So what is the meaning of enforceable by law and not mandatorily enforceable? It means certain rights are of such importance that you cannot enact Indian Constitution by not guaranteeing those rights. Otherwise, people will not be able to feel any difference after this independence. Because if you ensure that these are the guarantees given to you by Constitution, then people will feel, yeah, there's a change now. So those rights were given the status of fundamental rights part 3 because government was quite, you can say, able at that point of time to ensure that these fundamental rights can be given. Civil and political rights are actually part of that. And I discussed about this when we started fundamental rights part 3. When we talk about socio-economic rights, now these were given the status of directive principles of state policy due to numerous reasons. Other person, Mr. B.N. Rao, also supplemented this idea in Constituent Assembly. Yes, we should divide these rights into two parts. And this division was not so easy, my friends. In Constituent Assembly, many members were of such idea that no, let's pick these rights which you are putting in DPSP and let's put in fundamental rights. And then there was debate, right? Now, so we have DPSPs in part 4 of Indian Constitution, and it includes Article 36 to Article 51. Okay, so it is, you can say, the bandwidth of directive principles of state policy. Let's break the word itself. Directive. Directive means direction. And you know, direction is always necessary for progress. Principles means core ideas, means directions based on some core ideas. Of state policy, it means when state is going to make policy. So when state is going to make policy, these directions based on these principles need to be followed. But if you are not having any of these socio-economic rights which are mentioned in DPSP, you cannot go to court. No, I have not, state has not provided me this, because these are non-justiciable. It means you cannot go to court directly. It means this ease was given to state that when time is fit, you have enough resources, society is ready, political will is there, then you can actually make that. For example, DPSPs were talking about state responsibility regarding providing education to these children. But our government was not having enough capital to guarantee that every child in India will have free and compulsory education from 6 to 14 years of age. At that point of time, we were not having enough resources. But later, when we were ready, 86th Constitutional Amendment Act came and we saw that inspiration coming from DPSP, and then it was declared as a fundamental right under Article 21A. Right? Now, another differentiation between DPSPs and fundamental rights are, in fundamental rights, there were certain titles associated with type of fundamental right. For example, in fundamental rights after Article 12 and 13, we started right to equality. And within that, we discussed Article 14, 15, 16, 17, 18. 14 to 18 we discussed. Then we discussed right regarding freedom, right? But in case of DPSPs, there are no such titles present. Okay, no such titles are present. No such categorization within DPSPs are present in part 4. So now how we categorize them? So this categorization is done based on analysis of certain scholars, and they categorize this into 3 parts. So they categorize this into 3 parts, and those 3 parts are socialist, liberal, and Gandhian. And we are going to discuss this in detail. Socialist, liberal, and Gandhian based on the type of provisions which are there. Now, just take a look over this statement made by famous legal luminary, Mr. Granville Austin. So he says DPSPs are conscience. The word used is conscience of Constitution, antaratma. Right? So it means, जैसे कहा जाता है ना, you should act with your conscience. So states should act with the conscience of Constitution. And please remember, these kind of statements are asked in match the following. Okay? Borrowed this idea from Irish Constitution, and Irish Constitution borrowed this idea from Spanish Constitution. Now, guidelines to be followed by state while establishing policies, I have just told you. Apart from this, when we take a look over Government of India Act 1935, GOI 1935, so in that particular law, there were instrument of instruction. So instrument of instructions were actually given to Governor General as well as governors of provinces, that when you are going to conduct the affairs of the administration, these are the core principles you should keep in mind. So you can say instrument of instructions as mentioned in Government of India Act 1935 as well as Irish Constitution, we draw inspiration from both. And Granville Austin says it is conscience of Indian Constitution. Take a look what B.R. Ambedkar sir is saying. So the point which I've just discussed with you, that it draws inspiration from this instrument of instructions. Now, you should have this question in mind. Sir, you were mentioning about socio-economic rights, but why we need socio-economic rights? What are socio-economic rights? So it means rights which ensures that your social condition will not be a basis of your discrimination. You will be having access to resources of society, facilities of society like any other person. Don't you think this particular provision is much needed for the welfare of many people, right? And when it comes to economic right, can any one of you say that, sir, I don't need any economic right? Economic right means your right regarding having facility of ensuring adequate livelihood. It means कमाने के लिए, means आपको रहना है, you need to live, for that you need resources. But it is responsibility of state to give you such circumstance so that you can earn your resources. And when you are going to earn and when you are going to ensure that these resources are there, then only you can live, right? So socio-economic rights are very important. Now these rights are the foundation of the concept of welfare state. Welfare state. So what is the meaning of welfare state? Actually, this idea emerged in Europe at a time when exploitation in front of state got increased a lot as a product of industrialization, laissez-faire system where government was on back foot. Now let's connect what it means. So there was a professor in Glasgow University, Mr. Adam Smith. So he published a work, Wealth of Nations, and in that work he said government should be on back foot. Government should not regulate the market, and market should work on its own. That is for the best, and prosperity will come and everyone will be happy. Such were the, you can say, dreams. But what happened? Due to this, few people got extremely rich and others were getting poorer. And since state was not allowed to, it was said that state should not engage. So state was not engaging even for the welfare of these poor people, these workers. So severe exploitation was there. Now my friends, tell me what happened if exploitation is there. There is a possibility of instability, right? Lawlessness. So thereafter, this idea became popular that no, government should actually function as a welfare state. It means if some social conditions of the people are such so that they are not able to take care of the basic needs, in that scenario, state means in this case you can say state, government has to intervene and take care of the basic needs of these people, right? So this is the idea of welfare state, right? And in Indian context, these ideas of welfare state were prevalent way back, right? We had this concept of Raj Dharma. We had this concept found even in Arthashastra of Chanakya, that the prime responsibility of king, Raja, should take care of the welfare of its subjects, right? So they were present in Indian context also. Now, what is the aim of these DPSPs? So you can say that there are three aims, and now you can relate these three aims were present in preamble as well: equality, liberty, and fraternity. And these three are important to ensure socio-economic justice as well as political justice is important. And those who are thinking, sir, what is political justice? Why you need political justice? Acha, tell me, consider you are not part of political system. You are not given right to vote. Consider your opinion doesn't matter. And if your opinion doesn't matter, you don't have right to vote. Now government will be, if government makes certain law which are detrimental for you, means have negative impact on you, can you do something about it? No. But if there is political justice, you have a voice. You can be a seed for change. So political justice as an idea is equally important as idea of social justice and economic justice, right? So now, this is a fact. I've told you that DPSPs are not enforceable, not justiciable, right? It is prerogative of state. When they're ready, they can actually make determining the constitutional validity of law, right? So what does it mean now? So Supreme Court said that these are not enforceable, non-justiciable. You cannot come on knocking on the door, sir, this DPSP has not been followed. But Supreme Court can actually look at the validity of a law. It means if a law is made, and some of you filed a petition in Supreme Court, sir, this particular law is this should be null and void, it is unconstitutional. Then at that point of time, our government says, no, this is not unconstitutional. I made this law to taking inspiration from DPSPs. So now Supreme Court will see, oh, what is written in DPSP? Acha, this is written in DPSP that state has to take action to reduce the chances of inequality. And this particular law is actually making sure inequality decreases. So in this context, Supreme Court might say, yeah, this is constitutionally valid. Okay, I hope now you are clear about the meaning of this line, right? So we classify these DPSPs into three heads, as I told you. Socialist principle, Gandhian principle, liberal principle. And I told you, though, there's no specific title mentioned in DPSP such. It is based on an analysis. So when you talk about socialist principle, so when you read DPSP, just think, in this DPSP, priority is given to equality. Priority is given to welfare of society, not individual liberty. Right? So when these kind of provisions are found in certain DPSPs, we call them socialist principles. For example, these. Priority to society. Priority to bringing equality. Priority to reduce the concentration of wealth, then only equality will come. Right? Gandhian principles, ideas which are related to Gandhian ideas. For example, Panchayati Raj, intoxication, banning intoxication, right? So making panchayat self-sustainable, also about giving due protection to the milch animals, calves, right? So these are coming from Gandhian principles. When it comes to liberal principles, so it means priority is given to individual. That individual's choice should maximize and restrictions on that individual should reduce, then that individual will be able to enjoy socio-economic rights. So in whichever article we find this particular thought getting reflected, we call it, okay, this is liberal, you can say, principle. Now, this DPSP starts from Article 36. And Article 36 simply says what state means. So it says state is same as Article 12. And you know what is the meaning of state under Article 12? We discussed it, right? Legislature, executive at union level, legislature, executive at state level, local government bodies, panchayat municipalities, and other such bodies which perform the function of state. It means regulation function, right? So same is the definition of state here in this context. Now, some of you might be thinking, sir, why they have added one article, specifically Article 36 here, if they wanted to tell us that it is same as Article 12? Why they have added one more article? The reason is that we are talking about a separate part, a separate chapter, you can say, part 4, right? And I told you in the start that state word is used in two senses in Indian Constitution when we go through different articles. So when we say state here, so it means we are talking about different organs of government which perform the function of state, because state is there. But when it comes to this union part and state part, when we use the word state, it means we are talking about provinces, for example, Uttar Pradesh, Madhya Pradesh, right? To make it clear, that is why adding this was necessary. So it is a legal standard that need to be maintained. The state includes, we discussed it. Now, what Article 37 says? So Article 37 talks about the status of DPSPs, how you need to relate with DPSPs. So it expressly mentioned that they shall not be enforceable by any court but are fundamental in the governance. And please remember these kind of phrases, fundamental in governance. So UPSC will make a statement within part 4 of Indian Constitution, DPSPs, it is clearly mentioned that DPSPs are fundamental to governance. So some of you might thinking, yeah, fundamental governance. But this statement is saying, clearly mentioned, the word mention is there. So some of you might think, यार ये फर्की तो नहीं रही UPSC हमसे, कहीं घुमा रही हो, right? But yeah, it is mentioned, clearly mentioned, fundamental in the governance. Okay, these kind of statements. And it shall be the duty of the state to apply these principles in making laws. So this is 37. So how you can remember 37? First, non-enforceable status of DPSPs. Second, stated role is or importance is fundamental in governance. Okay. Now, coming to the Article 38. So now we are going to talk about socialist principles. Okay. So it says promote social, economic, political welfare of the people. Okay. So social, economic, political welfare of the people is a directive to the state. Now, a state can make certain programs, subsidies for the deprived section, and that if deprived section is getting these subsidies, then it can be considered as economic welfare of the people. Can you mention some government scheme which is specifically dealing with the welfare of women section? Come on in comments, because everything should be interconnected in your mind. That's how you can concise your knowledge and recall easily in exam. Yes. Mention in comments government schemes, they should be ready. Now, Article 39. I hope by now some of you are remembering. I'm giving you advice. Best way to remember government schemes and connect them with DPSPs is that you should structure these schemes in your mind. As I said, women. So within women, there should be some sections in your mind. Oh, with regard to women. So there are some schemes for pregnant women. Okay. There are some schemes where eldest women of the family is considered as the original holder of that scheme. I'm giving you a hint. Oh, there are some schemes for girl child also with regard to education. Right? There are some schemes for destitute women also. Right? We have many schemes. There's a dedicated program also. National Social Assistance Program, NSAP. There are other programs also, NFBS, National Family Benefit Scheme. Right? Matatva Vandana Yojana, Lakshya Initiative, a Ladli scheme. So many schemes are there. So easiest way is structure in your mind. Okay, then interconnect. Now, Article 39, to secure adequate means of livelihood for citizens. Don't you think it is connected to economic justice? As I told you, livelihood is necessary. So you should be provided job opportunities. Right? Because developmental model matters a lot. Right? Right developmental model matters a lot. And government has important role to play there. So it means within Article 39, first is talking about livelihood for citizens. Now B is saying equitable distribution of material resources. Then it is saying prevent the concentration of wealth. Now, how many of you are able to recollect that we mentioned about Article 39, subclause B, subclause C, somewhere in fundamental rights also? Come on in comments. Those who are not able to recollect, just check out what we discussed under Article 31C. That if a law is made by Parliament, drawing inspiration or based on Article 39 subclause B or subclause C, and it abridges in some way Article 14 and 19, then also that particular law will not be considered as null and void. Right? I hope now you remember. So these are the Article 39 subclause B, subclause C. And are you able to see that these articles, these subclauses B and C are based on socialist ideas? Because ultimate purpose is that equality need to be established, equitable distribution of material resources, and prevent the concentration of wealth. Distribution equal करें और किसी पर इकट्ठा होने ना दे. Right? Now, equal pay for equal work. Now, I hope you can connect this with feminism, right? Equality in context of rights of women. Then preservation of health and strength of workers and children against forcible abuse. Then you have opportunities for the healthy development of children. It was later added. It means 42nd Constitutional Amendment Act added 39 subclause F in our Constitution. Okay, please remember the amendment part specifically. Okay. Now, 39A. Please remember 39 subclause A means we were talking about this subclause within 39. Okay, which were talking about livelihood for all citizens, right? But when we say 39A, capital A, it means it's a separate article, right? And if 39 capital A is there, it means it was added later, right? Otherwise, if it would have been added at the enactment of the Indian Constitution, then they would have placed it in Article 40. But to have this constitutional scheme drafting intact at the later part, when amendment was done, it was added through 42nd Constitutional Amendment Act, and that is why A was used. Capital A means a separate article is being added. For example, 9B would be, capital B would mean ki, oh, there's another article, separate article is added. Now, promote equal justice and provide free legal aid. Now, can you mention certain, you can say, policy of government which is connected to, or you can be drawing inspiration from Article 39A? Come on. Nalsa, salsa. So I'm not talking about salsa dance. National Legal Service Authority, State Legal Service Authority. Along with that, there was another important initiative government took, telelaw. So these policies, telelaw, through common service centers, government is providing this facility. If you need some legal advice, then government independent lawyers are going to provide this legal advice to you, free legal aid, right? So this is 39A. So these policies were made taking inspiration from this DPSP. Then Article 41, secure right to work, right to education. Now, right to work, right to education, right to public assistance in case of unemployment, old age, sickness and disablement. This is Article 41, important article. So many policies are made by government taking inspiration from Article 41. Right to work. I hope all of you remember MG Narega, Mahatma Gandhi National Rural Employment Guarantee Act. Right to work, right? Right to education, Article 21 is expressively, especially mentioned. Right to public assistance. It means in case of unemployment, government provide, right? Unemployment allowance, old age. There are old age pension by Ministry of Social Justice at center level, and state government, there's Ministry of Department of Social Welfare. So this is a centrally sponsored program. You can search about NSAP. I just mentioned it also. National Social Assistance Program. So public assistance, NSAP, this program, this policy drew inspiration from Article 41. Okay. So in a question where they want to ask you about the developments which you have seen as a contribution coming from DPSPs, you can mention these links also. Okay. Sickness and disablement. So government provide, aid, support to in case of sickness. For example, government spend on these public health infrastructure. Also, Ayushman Bharat Yojana, right? Now, and with respect to disablement, how many of you are aware of this PSU Alimco? Please search about it, Alimco, and see how it is connected to Article 41. Now, Article 42, make provisions for just and humane conditions for work and maternity relief. And you know that we have improved a lot in context of maternity laws in India, right? So Article 42, then 43, to secure living wage. It means wage which is bare minimum for your life. Decent standard of living, social cultural opportunities for all workers. Workers, it means we are still in socialist dimension of DPSPs. Then 43A added through amendment, 42nd Constitutional Amendment Act. What it says, participation of workers in the management of industries. Don't you think it is connected to providing policies with respect to trade unions, their participation in the management, right? And I think 2015 or 16, UPSC asked this as a statement. The statement was, which of the following are not part of DPSPs? And one statement was this. And many students who were not well versed with the provisions mentioned in part 4, they thought, oh, how can workers participate in the management of industries? So because when you actually read this word worker, so what comes into your mind? Your mind talks about, or you have idea, okay, worker is someone who is having some, menial work that person is doing. When I'm saying menial work, it means the person who is doing some hand holding kind of work, or you can say the basic work, right? But every work is important. That is the idea behind 43A. No work is menial. Intellectual work and physical work are same. But when you say worker, what comes into your mind? Physical work. But if someone is a manager also, that person are using intellect, that person is also a worker, na? Right? So this is the socialist idea. And why it was added? Because if there is no participation of workers in industry, and every kind of worker, who is an employee, whoever is an employee is a worker. So what is going to happen? The person who invested the money is going to draw the maximum out of profit and actually minimize the wages or salaries which need to be provided to these workers, and it will lead to inequality. Such should not happen. And how we can ensure such condition doesn't happen? Only when there is participation of workers. Okay. Then Article 47, raise level of nutrition, standard of living and improve public health. Can you mention some government scheme, policy, drawing inspiration 47? There are so many schemes. ICDS, midday meal scheme. You can directly say Poshan Abhiyan. Poshan Abhiyan. Modi ji launched it from Jhunjhunu district of Rajasthan. So the Poshan Abhiyan, right? Along with this, you can also mention NFSA, National Food Security Act, PDS, TPDS, all of them, these policies are drawing inspiration from 47. Now, Gandhian principles. First of all, Article 40, most popular article, organize village panchayats and endow them with necessary powers. Necessary powers. Can you mention some policy? Law made by government. 73rd Constitutional Amendment Act. So this act declared that these Panchayati Raj bodies are now on constitutional bodies. So it was drawing inspiration from Article 40. Then 43. So 43 is Gandhian principle. So we have categorized them into segment, means principles, means philosophy from which they are emerging. The state shall promote cottage industries. So Gandhi used to say cottage industries are necessary for self-reliance. So can you mention some law regarding promotion of cottage industries, some body? Come on. KVIC, Khadi Village Industries Commission. Just check about PMEGP, Pradhan Mantri Employment Generation Program, and how it is connected to village industries, right? Now, 43B, again, it was added through Constitutional Amendment, 97th Constitutional Amendment. Promote cooperative societies. And when we were discussing about Article 19, there also I mentioned this 97th Constitutional Amendment Act was used to amend Article 19 subclause 1, and now you can say establishing cooperative setup is also a fundamental right. Cooperative society, such is the importance. Because why such importance was given? Because government cannot be considered as the solution provider to every problem which is there in society. This is a faulty conception. If you see any problem in your society and you look at the government, what you have done? That's a wrong conception. Because solution should come from society as well. Right? So we can come together. The word cooperative comes from the word cooperation. We should come together and build some solution in this regard. And government should work as an enabler, not the provider of, in every case. That is the idea. And we have so many examples in different sectors where cooperative model has helped a lot. You can check about the concept of green bank and how this concept is solving the problem of hunger. You can also search about this, it's the most popular, this Amul model, Amul Doodh Pita Hai India, and how it has transformed the life of so many dairy farmers, right? Now 46th, to promote the educational and economic interest of scheduled caste, scheduled tribe and weaker sections of the society, and to protect them from social injustice and exploitation. Do we have some policies in this regard? Come on, fast. Yes, we have. We have seen government established through constitutional amendment a dedicated commission for National Commission for SCs, National Commission for STs. There's dedicated ministry too. There are dedicated schemes also, establishing various hostels across India where the students can live on subsidized rate. They can study on subsidized rates, right? So these policies are drawing inspiration from 46. 47. Intoxicating drinks and drugs need to be prohibited. And do you know certain law? Come on. NDPS. That was quite in news during this Aryan Khan case, right? We have NCB, right? And various state governments also have their drug de-addiction policy, a dedicated policy. Now, Article 48, prohibition of the slaughter of cows, calves, and other milch and draught cattle, and to improve their breeds. Now, the word cow is mentioned in our constitution, but along with this, other milch animals and draught animals, cattle are also used. Okay. Now, improve their breeds. Can you mention some government scheme, policy drawing inspiration from Article 48? Come on, fast in comments. Rashtriya Gokul Mission. How can you forget? Government is improving, these breeds, indigenous breeds, right? And you should also know about these basic questions. What is the difference between A1 milk, A2 milk, which were associated with these Rashtriya Gokul Mission, right? So you should keep an eye on that. Now, what are liberal principles in DPSPs? Article 44. It talks about Uniform Civil Code, UCC. There has been a lot of debate on implementation of UCC in India. It means no personal laws. There should be one uniform code for all, right? Article 45 provides early childhood care, education for all children until 6 years of age. Do you have some policy? Yes, ICDS, Integrated Child Development Scheme, which targets children below 6 years of age. We have Anganwadi centers giving them food as well as basic education. When we talk about children from 0 to 6, so there's facility of weaning food, WEANING, weaning food as a policy of government. You can consider weaning food as government Cerelac, So this is drawing inspiration from 45. There's another word for that also, that is Panjiri. Now, Article 48, organize agriculture, animal husbandry on scientific lines. So we have a dedicated ministry for that, right? So this has been added as elementary education has been added as a fundamental right. We discussed it earlier. Now, Article 48A, protect and improve the environment and safeguard forest and wildlife. So it was added through 42nd Constitutional Amendment Act. So we have numerous laws made by government with regard to protection of environment. We have a tribunal also, NGT, right? Along with this, we have other state level boards also, central level boards also to protect environment, right? For example, CPCB, Central Pollution Control Board. Now, Article 49, protect monuments and objects of historic interest which are of national importance. Article 49. So, you can remember, the government launched the scheme Rashtriya Dharohar, right? In which CSR funds are being mobilized for the upkeeping of these monuments, right? Article 50, separate the judiciary from executive. This is also a DPSP, please remember that. And it was important considering in mind the independence of judiciary, right? And clarity in the functions of these two important pillars of our democracy. Then we have last article, Article 51. My friends, we were just talking about features part. Features, understanding, knowing about these features are important. But the next level is debate between fundamental rights and DPSP, the laws and the development. This is the last article here, Article 51, promote international peace, security, maintain just and honorable relations between nations. Article 15 is a reflection of India's foreign policy. Or you can say Indian foreign policy is a reflection of Article 51. Because we believe that international peace and security should be maintained. We should have honorable relations between nations. Respect international law. We respect international law. Unlike China, in many cases, in recent past, treaty obligation, settlement of international disputes by arbitration. And I must quote Mr. Modi ji. He was saying that India is going to be arbitration capital of the world. It means world will come to India for resolving their conflicts in amicable manner, right? So this was a brief go through from this DPSP part. In the upcoming session, we are going to deal with the substantive part of DPSP. See you in the next session then. So about the courses which are present at StudyIQ platform, there's this offer going on, double validity. If any course is having 1 year validity, then it will be extended to double. You can use this code Tyagi33. About the PDF, this PDF will be available in Shashank Tyagi 4U Telegram group, and you can reach me out at Insta or Twitter. I will be there to help you out in any case. See you.
StudyIQ IAS. अब तैयारी हुई अफोर्डेबल.